ntokwa Kesi pana si parliament anya asempetwa ne na veti ya omo veti edifa Akufo-Addo new appointees edifa Supreme Court judges awodi omko no ene na chese omatena se omo veti na so no akowie achinyeje Kesi pa anya asempetwa NDC minority for our oppose those things such as Akufo-Addo persuading we implemented during the vet and yes and to hire for NG bomodian service subscribers and be near my door adding so better no hana open sabico so I can share maunia so yende enye binti no nye bifi yes already yemfi ni chimney and kade one chairman this year the nichimo parliamenta a why she papa panyas and to NDC minority for sorry say omompene yes omompene with omwankasa adwon with the constitution achese matu bia mane Akufo-Addo awone presidents we asenketo enne judges ya appoint o achese de ombeko Supreme Court no omaba parliament during committee sitting omako ho achese ngwase ya embarrass ye pa anya asenketo NDC minority sorry say omompene with this new appointee Akufo-Addo enfomonko enkofo kra so mberita inumpo even though I abuse you, we think of to be retire. Until we be leave your office, sorry, we be leave your office. Quay, now no a president beba. Oh, Nkofuni nyan retire, who appointing for that. So Nkofo kwa, not just on my question. Like, then why? See, as you speak, say they need more a parliament, why is she saying as a video question, answer with the uncle, said they are almost things near the echo. Or more oppose this a new appointee, including Kutiomo.
Honorable members, I think we've been so unfair to the nominee, bringing her in here and then start this discussion. But please, before we can proceed to take the questions, I want to recommend that we suspend sitting for just about 10 minutes.
Okay, 10 minutes.
10 minutes.
10 minutes. You keep saying something. No one here is being unfair to the judges. When you go to court, hold on. This idea, hold on. No. That we are being unfair to the nominee. Where from this one? That when I go to court and the court is doing their work, I should say that they are unfair to me because I've been sitting in the chamber for long. Is that the interpretation of how things work here? Is Parliament not another way of government? I also recommend that the 10 minutes is too short. You are too ambitious about what you can achieve in 10 minutes.
I'm wondering because please, let's suspend for that 10 minutes and go to conclave in the inner conference room and then come back.
Okay, so we meet
Thank
where?
you.
Where do you want us to be?
The inner conference room. Definitely. Please sit and let me.
Madam Chairperson. Madam Chairperson.
Madam Chair, very respectfully.
Honorable.
Yeah, Madam Chair, very respectfully. Very respectfully. Very respectfully, Madam Chair, this is what the rule says. Respectfully, Madam Chair, this is what the rule says. Madam Chair, can I kindly refer you to the rules?
Honorable member.
Let me refer you to the rules.
We were very clear.
Madam Chair.
And this committee can never exceed 15 members.
Madam Chair, please can I refer you to the rules?
The 4 is 15. And it's period.
But can I refer you to the rules?
No, please. We have gone through the rules.
No, Madam Chair, let me refer you to the rules.
Which rule?
Madam Chair, the rule says that order 2217.
Honorable, you are out of order. Please.
I've been denying my right here.
No, you don't have any right.
No one is defending my right here.
No.
I have a right as a member of the Judiciary Committee to vote on this matter. I have a right to vote on this matter. I have a right to vote on this matter, Madam Chair.
Honorable, so far as this committee is concerned, there's a motion on the floor.
It's never come up before. I've been on the committee. We've vetted a number of Supreme Court judges. I believe that issue affects most of them, but it never came up. But I want to raise it today. One, the president said he is making the appointment pursuant to his powers under Article 144. Article 144 says, a Chief Justice shall be appointed by the President acting in consultation with the Council of State and with the approval of Parliament. The other Supreme Court judges shall be appointed by the President acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. The offices of Supreme Court judges are created under Article 128 of the Constitution. And this is what it says. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. The Chief Justice and not less than 9 other justices of the Supreme Court. Now, as we speak, we have 15 justices on the Supreme Court. We're told that one is retiring, but we have 15 justices of the Supreme Court. It means that we have 9 plus the Chief Justice making 10 and an additional 5, making it 15. This letter states that 2 of the 15 are about to retire, and the president is seeking to make early arrangements to make sure that there's no vacuum when the 2 do retire. One has retired already, the other is about to retire. The legal issue that I'm raising before this committee, which should be captured in our report for discussion, is this. Whereas the Constitution in Article 144 says the president shall appoint the justices, there is nowhere in this Constitution that the president is given the power to increase the number beyond the 9 plus 1. Nowhere. And I challenge anybody in this room to show me any provision in this Constitution that says that even though Article 1281 says 9 plus Chief Justice at the minimum and you don't have an upper ceiling, that the person to decide that upper ceiling is the president. Who says the person to decide that upper ceiling is the president? Who? To show me which provision. That he can, anytime he feels like, and I'm not talking about this president, previous presidents have done that before. So it's not about this particular president. Any president, anybody should show me anywhere in this Constitution where power is given to the president to increase the number above 9 plus 1. No such power is given to the president. Now, we have had a practice where presidents sit and as and when they feel like, they just write to us, I have appointed this person, process him for her to become, or he to become a member of the Supreme Court. No provision is made for the enhancement of the numbers. This is my position on the matter. Article 298 of the Constitution is clear on this matter as well. There's a provision. 25 of this Constitution, where on any matter, whether arising out of this Constitution or otherwise, there is no provision, where there's no provision on any matter arising out of this Constitution, express or by necessary implication of this Constitution, which deals with the matter that has arisen, Parliament shall, by an act of Parliament, not being inconsistent with any provision of this Constitution, provide for that matter to be dealt with. So, in the absence of an express provision on the specific issue on the upper ceiling, it is Parliament that should from time to time pass legislation setting the upper ceiling. Not just any president gets up and says, I want it to be 15, I want it to be 30. It has to be Parliament passing the legislation. It could be proposed by the president, fine, but Parliament has to pass that legislation. I have an example in the Indian Supreme Court, the Indian Constitution says the number is 7 for the Indian Supreme Court. Today, we have an Indian Supreme Court Number of Judges Act, and that places the number of judges at 33. Yeah, not exceeding 33. So each time they want to increase their number, they have to go to their parliament. The parliament will pass a legislation, increasing the number. Anybody who says I'm wrong and says that the president has a discretion, even though nothing is said about the president being the one to determine the number, it only says that he should appoint them. But it doesn't say he's the one to decide the upper ceiling. But assuming you even say that the president has the discretion, we all know that the exercise of discretionary power comes under Article 296. And again, the same mechanism of parliamentary approval of the number is provided for in 296. And 296 says that where in this constitution or in any other law discretionary power is vested in any person or authority, where the person or authority is not a judge or other judicial officer, there shall be published by a constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this constitution or that other law to govern the exercise of the discretionary power. So even if you say that, oh, the president has the discretion, a discretionary power, the exercise of it is governed by Article 296. So the president ought to have brought a constitutional instrument to Parliament saying that I intend to place the upper limit of the membership of the Supreme Court at 15, even though the Constitution says that the Constitution's minimum is 9 plus 1, 10. I intend to make it 15. And then this will be taken through the process of approval of constitutional instruments by Parliament. If 2/3 of the House says no, we don't accept it, then they have to remain at the number that they are. If 2/3 are not mobilized to block it, then we now have a law that places the upper limit of our Supreme Court at 15. And then we, as Parliament, can then process nominations to fill the vacancies. Bearing that, I think that we have been doing an illegal thing, an unconstitutional thing. The president has been exercising the power without any foundation in the Constitution or any law that I know. And I want to raise it and have it captured that I object to the nominations on the basis of the fact that it is unconstitutional, it flies in the face of Article 128 of the Constitution, and it is not founded in Article 144 of the Constitution. It offends the discretionary power provisions of Article 296.
Busianfo ni video kakra ye twa bre matches yin na hwe de koso a chese enya senketwa ye hwe se die NDC minority for na sorry with a very excessive powers such as omo chese omo mpene dam dom na besi form e ma de akofado ye no omo ntina o maninye aden osoto auto presidency wa na de da wa kwen ma sorry ya mpese me appoint sankofo we na o de abana chese omo abano Oma pass it through process. Yeah, vet on it. Yes, why? Even US Kesi, Supreme Court judges in Drusa. I don't know one record be a best biano. A record that is a beansy that would you want to say. I don't set a good record in my Ghana. Our record be a best biano. You want to say. And dear, wow, you Ghana no. A man for can. Jai na wunjaya da ko betima da boni ama nti hwe vet na senior ekwo so na enya asenketo o master on their toes say o be rejected oppose even that vet no cramp no so mpese be koso vet no ho na kra mo mpese be koso kan pese akwa da parliament ama o debate on o mpese matutu judge ni no about na no cramp ebusibisa no question po like a young makuma ya say constitution I didn't no crow and so ye nim e de bubu ye ni gu nemu bi so enye ni a pass no moko enye ni a pass no moko saa na dia bedu saa bre saa ne dia bedua ye ko elections enema a wo se yedwen ho no enye bi ni de na ija na de be yenko vet ne enko yeyo because already na nkasa nipa wo ho no wo ho sisi no even though se 2 se 3 krampo retire nipa still ne beka ho sisi no president bia appoint nipa nko ho sa omukofi mpo so mukofi a president bia appoint nipa kra with the number of people left in the krampo no president bia appoint judges kranko ho sa da nko a record a wo set no tinene wo hwe ato forcing wo hwe ye deputy ye minority leader just wo hwe omo dimina just omo si chale omo ntiase ntebe ya judge na wa ba no sorry nkofi on sorry omo person be hu nanim a je ni ye de ye hwe ho a bitima che adwo subscribe na share mon yaso ye de insanke no nso hu de ko anate NDC for minority dominance from the bitima bon baso se na be adwumade omo no ye bitimi account for no makoso ahead ayesama Ghana nyina ana pese di musi Akroma